ladies and gentlemen, our esteemed viewers at home. Welcome you to another edition of Democracy and the Rule of Law, the show where we dive deep into the critical issues of law, politics, and governance. In today's episode, we'll be looking at two very important topics. First, we'll be looking at the issue regarding the recent conviction of Mazi Nnamdi Kanu, the self-acclaimed leader of the indigenous people of Biafra, IPOB. Of course, during the week, we saw the judgment emanating from the Federal High Court in Abuja, sitting in Abuja, by the Judge James Omotosho, in which he was convicted of charges bordering on terrorism and was consequently sentenced to life imprisonment. Of course, that judgment have generated a lot of conversation around the issue of fairness, around the issue of repeal law. Of course, some persons have contended that the law in which he was convicted is a repealed law, and some have even contended that he was not given fair hearing. So we'll be looking at all the legal issues, that have cropped up with regards to this recent judgment. Also, we'll be looking at the new Lagos State Tenancy and Recovery of Tenants Bill, which is presently in the House of Assembly of Lagos State. Of course, the bill has been tagged a game changer because to revolutionize the relationship between landlords and tenants in Lagos State. Of course, the issue bordering on agents of fee, the issue on recovery of premises, and even the duration of tenancy are all embedded in this new tenancy bill. So we'll look at the legal issues emanating from this on this show this evening. So stay tuned. We'll go on a very short break, and when we return, we introduce our guests who are already seated in the studio this evening to help us make sense of all of this legal issue. I am Kenneth Wimo. We'll be back very shortly. If you are just joining us here onto your favorite program, Democracy and the Rule of Law, just like I said before we went on the short break, we'll be looking at the issue concerning the judgment or the conviction of Mazi Nnamdi Kanu and the recovery of tenancy bill, which is presently at the State House of Assembly in Lagos State. With me on the show today is Barrister Obiora Ume, a legal practitioner and human rights activist. Barrister Obiora Ume, we want to welcome you to the show this evening.
Thank you very much, and a very good evening to our esteemed viewers there.
All right. I'm sure we'll also be introducing our Zoom guests who will join us shortly, so as the show proceeds. So, Barrister Obiora, without wasting much time, I think it's appropriate to go into the nitty-gritty of today's topics.
Yes.
Because the first is the conviction of Mazi Nnamdi Kanu, the self-acclaimed leader of the indigenous people of Biafra.
Yes.
IPOB. Of course, we all read or also the judgment delivered by Justice James
Omotosho. Yes.
The Abuja High Court.
Yes.
So, of course, it has generated a lot of legal opinion. So, what is your say? What is your opinion concerning, all of the issues, arising from that judgment?
Yes, thank you very much. We look at the issue from two angles. One is the legal angle, and the other is the political angle. The legal angle has to do with his arrest, his trial, and conviction by the Federal High Court seated in Abuja. The other side of it is the political angle to it. And let us first start with the political angle. What were the agitations that Nnamdi Kanu stood for? What made him to have a followership that he had at the end of the day? And could the issue have been dealt with politically instead of trial and the conviction that finally, came to pass a few days ago. If you look at this nation, Nigeria, you discover that since the end of the Civil War, the Igbos were kind of a group that perceived that we are being marginalized. Although with his large heart, Gowon declared at the end of the 30 months battle that there was no victor, no vanquished. But incidences thereafter tended to show that, there was a kind of marginalization, oppression, and all that against the Igbo people as a people that lost in the war. And after a time, the things started to go down, and you recall that during the tenure of Babangida Abibi, when he visited Igbo land and created some states out of the enclave that we know as the Southeast, was given a title. What is that title? Ogugwa Wandigbo. That he was the man that came and tried to kind of make the Igbos to stop crying. That before then, they have been crying. IBB did that, created some states, and that was this. And then, still date, some Igbos still believe that they have not been given equal opportunity with other major ethnic groups in the nation in terms of positions of leadership, in terms of resource control, in terms of, their rights being acknowledged, recognized, and, enforced. If not for Goodluck Jonathan, who, had the opportunity of being the president of this nation some few years back. How many Igbos have had that opportunity? And in the past, we had 3 major regions: the Yoruba, the Hausa, and the Igbos. So with these things, those agitations, first not from Nnamdi Kanu, there were some agitators, but the major players in that scene were people like Ralph Wazuike. He came with his mass-up movement, and a lot of Igbos, supported. And eventually, for reasons known to his organization, they fizzled out. And IPOP came on board. Now, the issue is those agitations that took place that made some of these people to be demanding for their resource control, their rights, and the right particularly to be assured that they have equal rights with every other Nigerian. That whosoever is a Nigerian, by the constitution of the Federal Republic of Nigeria, there is equality. That the nation is a nation built on different levels. Some higher citizens or better citizens, or like the novel animal farms, all animals are equal, better, some are equal than others. That played out.
So you believe that that's what gave rise to the agitation of the Nnamdi Kanu and the rise of IPOP?
Exactly. Those were the things that gave rise to the agitations, the discontent, the grievances, and the politically This it ought to be solved using the arena of politics. Because you recall that in Bayelsa and some other areas, they were agitations.
Are you saying that Nnamdi Kanu's conviction is not grounded in law, but on political expediency?
Yes, I'm still coming to that. I'm not looking at I'm still coming to the issue of the trial, the conviction and all that. We're trying to look at what caused it.
Yeah, but they should have looked at it politically.
Yes, what I'm saying is that Nnamdi Kanu ought not have been singled out for trial, conviction, and all that. If at the right time, what was the right time? The time the agitations commenced, they allowed it to get to a point that personally, even myself felt that they were, going against the bounds of reason in the way they carried the agitation process. If at the initial time, the government, like the resource control demands for the Bayelsa people, the government came into it, it was resolved. Of course, we know that at a point, the people were equally making serious agitations. Even to the point of, allegedly using bomb to say, we don't want our resources to be taken and we are impoverished. Dokubo, Asari Dukobo, and these people, they agitated. Although some of them were arrested and arraigned, at the end of the day, government used political solution. What was the political solution? Government gathered them together and said, okay, we understand your agitations, we understand your grievances, we are going to address them, and those issues were addressed. And today, do you still see agitations there? The answer is capital no. But in terms of the Southeast, that has not been fully and comprehensively addressed by any government that I have known of. And that is what brought Nnamdi Kanu's issue. Nnamdi Kanu stood there saying that the Igbos are being marginalized and they want the Igbos to secede by way of self-determination.
So have you read the judgment that was given by
I will analyze the judgment for you. I'm coming there. Now, when the agitations, commenced and they started IPOP, of course, the federal government prescribed IPOP. What I expected is legal advisors to have done, first and foremost, there was to take steps to apply to the courts to the prescribed IPOP. Because it was gazetted, the legal advisors ought to have done that step be taken, because to start with, the right to self-determination is recognized in law by international law and instruments. And
was he charged because of his agitation for self-determination? Is he why he was charged?
He was arrested
because of his.
He was arrested and charged
because of
to court. Because of the activities, the way they were going about the agitation.
But not for his call for self-determination. But if for his call for self-determination.
That is the number one reason, secession. Because the major issue is that he was agitating and carrying out activities that tended to show that he and his followers do not belong to the entity called the Federal Republic of Nigeria. In pursuit of what they were gunning for, they went and established Radio Biafra, which I don't endorse as an individual. Myself, as a person, I have areas that I don't believe they ought to have gone that far in the issue of agitation for self-determination. It is a right recognized by law. The law says, yes, if you have gone ahead and carried out a kind of assessment, referendum, assessment of the number of people that are for and against
Yeah, but
your agitation.
That's what I'm asking. You said that it's recognized by law, and Nigeria is part of the signatories to some of this international convention that recognizes right to self-determination.
Yes.
So you said you've gone through the judgment. So was he convicted because of his call for self-determination, or for other reasons?
Now, from the judgment of the Honorable Justice Omotosho, he convicted him for 7 counts, and those counts border on criminal activities such as killings of police officers, military officers, and some innocent citizens of Nigeria in the pursuit of the agitation. And you recall that I said earlier that when the agitation started, the government did not respond, and the convicts and the followers went about it at a point the wrong way. What do I mean when I say they went about it the wrong way? There is no justification for killing others in the quest for self-determination. There's no justification for declaring sit at home. That does not appear to solve the problem he wanted solved. There was no reason to have gone ahead.
So you agree with the federal government? If you agree that all of this, there was no reason to do all of this, which you clearly did.
No. You need to take action. We need to be careful on the issue and the analysis. Nnamdi Kanu was arrested, and individuals that were tendered, and the evidences that were there. Most of these atrocities, which personally I condemn, like killings. I was in part a particular lady from I think Imo State or so, who was to get married to another military lady, to get him to another military officer, and they went down there. At the end of the day, both of them were killed. Simply because they were, in army uniform.
Yeah, because of time. Now, let's just see how we could dissect it, because obviously this is a very wide topic. So let's look at the judgment. Because the judgment generated a lot of uproar.
Yes.
Now, we alleged that the judges do not know the law. Of course, we saw him say that in the court. He said that the law in which he was charged is unknown to Nigerian law, and he was asking them to show him the law. So what is your opinion on that? Was he charged on a repealed law? And if that is the case, was that supposed to be in the first place?
No. First, I watched the proceedings when he, came out and was saying that the judge and even the lawyers don't know the law, and that he knows the law and so on, and that he was charged under an unknown law.
Yeah, was he on an unknown law?
Now, we know from the judgment of the Supreme Court in Alco and Fagbemi that if you charge somebody under an unknown law, the charge, the proceedings, and everything is a nullity.
So was he actually charged?
Now the question is, was he actually charged on an unknown law? He was charged for terrorist activities, then killings and all that. I do not agree with him, one, that the judge do not know the law. or that the lawyers don't know the law. I don't agree with him on that.
All right, another issue.
On the other issue of whether he was, because one thing is that he himself thinking that because he had already gotten victory partially at the Federal High Court, because you recall that when Professor Michael Zekome, his ex-wife counsel, was in charge of his case at the Federal High Court, he had 15 counts. And out of the 15, they were able to knock out 8 at the Federal High Court, remaining 7. And they proceeded to the Court of Appeal, and the Court of Appeal knocked out the remaining 7 and declared him a free man. Kanu proceeded to, the federal government proceeded on appeal to the Supreme Court. The Supreme Court said, go and face your trial. That there are allegations against you that you need to answer to.
So do you think he was right in opting to defend himself? Because we saw that he opted to defend himself in the trial. And of course, he didn't even open his defense. And what are the implications of all of this? Because that seems to have impacted the judgment, right?
Yes.
People do not understand the legal consequence of not opening your defense in a criminal trial. So can you help us to, help our viewers understand, the legal intricacies of what it means when you do not open your defense when it has to do with the criminal trial?
Yes. The law is clear that once there's a criminal allegation against a person or group of persons, the burden to establish that the person committed that crime remains on the prosecution or the state, as the case may be. There is no compulsion on anybody to say anything as far as criminal proceedings is concerned in his defense. The burden lies, we call it the legal burden. The legal burden to establish the conviction of anybody lies clearly on the prosecution, and it never changes throughout criminal proceedings. Of course, there's the evidential burden. The evidential burden is when a person asserts in the course of the trial, and that wants the court to believe a particular set of facts, that person has the burden to bring evidence in proof of sin. For example, if somebody talks about alibi, yes, that he was not at the scene of the crime, it is duty to furnish the evidence. Then let's look at the issue of Nnamdi Kanu. Nnamdi Kanu had a criminal trial, yes, that 5 witnesses testified, and they made serious allegations against him, damning allegations, and it was very wrong for him to have refused to give his own side of the story. A very wrong approach.
So you believe that he was ill-advised?
Yes. Also, for him to have sacked all his lawyers and decided to do it by himself, and then coming out with a list of people he wants to call as potential witnesses for him, of which His Excellency, the Executive Governor of Lagos State, was one of the witnesses for Nnamdi Kanu, and others, when he said he was going to open his defense, and suddenly he made a somersault and said he was no longer going to open his defense, that there was no case against him, and so nothing for him to defend. Wrong. He ought to have gone to tell his own side of the story. And like I said initially, that this thing needs to be looked at critically. One, there were killings and criminal allegations. Was those things, were they done at the instigation instance of Nnamdi Kanu, or were these things done by people who hijacked the agitation? Of course, it's clear that he was arrested in a hotel room, not at the scene of the commission of any crime, so to say. Then they produced evidence of the fact that Radio Biafra was established without license from the appropriate licensing authority in Nigeria, the NBC and others.
Okay, so now that he has been convicted, what do you think is the way forward? Well, what are his options?
Well, now he has been convicted, and I believe the proper thing now for him to do is to take up an appeal against the conviction.
Yeah, but some I even suggested that the prosecution could even appeal, because the law stipulates that the counts on which he was that
is a death penalty.
Carries a death penalty, but the judge, in his own wisdom, had to vary that, and he didn't have any right to do that. So even the prosecution could do a cross appeal, so would it be wise for him to appeal, given the fact that he even got a lighter sentence?
Yeah, you see, the fact remains that only God knows what to come out of whatever legal steps he wants to take. But looking at it generally, there are areas he could explore. First, it is still fundamental law in our jurisprudence that there is territorial jurisdiction. Territorial jurisdiction in criminal proceedings, even in civil proceedings. If a crime is alleged to have been committed in a particular territory, you don't use your whims and caprices to take the person to any place of your choice, either for convenience or what in legal terms is called a forum shopping.
Are you saying he wasn't supposed to be taken to Abuja?
That is exactly the point I'm making. That the alleged offenses were committed in the eastern part of the country.
Yeah, but the judge, if you write, the broadcast was listening.
Hold on. I know that the judge in the judgment said that he had jurisdiction because the broadcast was aired throughout the country. And that gives him jurisdiction. But let's look at it. Something is aired. You had it in Abuja, in other parts of the country. Was it aired from Abuja? The answer is no. It was not aired from Abuja. They received it there. Where was it aired? Where is the source? Source not in Abuja. And you remember that the Radio Biafra was just an aspect of the whole thing. The major thing is the agitation. The major thing is the purported declaration for a state of Biafra. The major thing is the plan for the purported plans for self-determination. Where did it originate? Where did the activities take place? In the southeastern part of this nation. And that is the area that the court ought to the matter ought to have been disputed in the first place. They ought to have filed the proceedings there, because that is where the matter or the alleged offenses took place. And of course, the Supreme Court in a number of cases had cause to set aside proceedings because they took place in the wrong territory. In one of the cases where EFCC arrested somebody in Kwara State for an offense that allegedly took place in Lagos. The matter finally go to the Supreme Court, and the Supreme Court stated clearly that territorial jurisdiction is still part and parcel of our criminal jurisprudence. And that you don't choose a place of your own to go and arrest a suspect or defendant because you believe that is where the proceedings will be more convenient for you. Go to where the thing allegedly took place.
So you believe that
so he could explore the issue of jurisdiction, particularly the issue of territorial jurisdiction. It does not matter that the judge said he had jurisdiction. It is not the judge that declares his jurisdiction. It is the law. It's the law that created the court that gives jurisdiction. Jurisdiction is statute based.
One of the issue concerning his final written address, which he alleged that wasn't the judge didn't allow him to make his final written or file his written address. Now,
on the we said that he could explore an appeal.
Yes.
The issue of jurisdiction is fundamental, and if the court of appeal agrees that the venue for the trial, the Federal High Court in Abuja, that court lacks jurisdiction, the whole proceedings, including the conviction, will be set aside as null and void, because jurisdiction is the lifeblood of every proceeding. It's the blood of proceedings in court. And any entity that does not have blood comes to what?
All right.
Extinction.
Finally, let's look at.
I still have other things to talk about.
Because I have barely 2 minutes. Let's look at the issue of fair hearing. Because the principle of fair hearing purports that the defendant should be given adequate room to prepare for his trial.
Yes.
He has been transferred to Sokoto correctional facility.
Yes.
And he is defending himself. So how is he going to prepare his appeal, given the fact that this also have a timeline? Wouldn't that affect his right, for fair hearing? Because he wouldn't have the facility and the things he needs to adequately prepare, to appeal his case. So how does this work?
Yes, that is another issue. Another, a violation of his right. Even convicts, they still have rights under the law. The fact that the person has been convicted does not, take away from the person the basic rights he enjoys. And in this instant case, Nnamdi Kanu was tried in Abuja and was convicted there. While moving to Sokoto State. Why? Where it will be difficult for his lawyers, or his, maybe he may want to retain lawyers this time around.
His consultants.
Who's the consultant? I call the consultant. Fine. Yes. Where it will be difficult for them to have access to him. It is, perceived violation of his rights. And again, the other question is, does it lie within the whims and caprices of the prosecuting authority after conviction to send everybody to any correctional custodial center? Although the instruction, the Honorable Justice Omotosho said that he could be taken to any of the correctional centers in the country. But he can still challenge that.
All right.
And then the areas I believe he can also explore is the issue of fair trial.
All right.
And of course, that fair trial is different from fair hearing.
All right.
The issue of fair trial has to do with.
But we are almost out of time on this topic. Of course, it's a very, very broad one, and hopefully we can have some other time to look at it. We'll now go into the second. We'll go on a short break, and when we return, we'll look at the issue regarding the new tenancy law in Lagos State. Stay tuned. We'll be back shortly.